Now I'd like to introduce Neha Jayaswal from Abbott Laboratories here in Dubai. She's in-house IP counsel supporting emerging markets in IP for Abbott. Thanks.
A very good morning to all of y'all. I hope each of you have had a great start to the new year. I'm so excited to be here. I'm so excited to be here to talk on this topic, which I'm so passionate about because I started my career as a patent analyst. To introduce myself, I'm a patent counsel for Abbott Laboratories, and I handle all IP-related matters for all the emerging markets. Today, I'm going to be focusing on freedom to operate searches and landscape analysis and the importance of conducting freedom to operate searches for successful launch of product. This is to provide an overview of the topics that I'm going to be touching upon, IP and business. With ever-increasing competition in business, IP has become a crucial differentiating factor. What is freedom to operate? An FTO search is basically a process which is used to determine whether a company can launch product on the market without the fear of infringing valid or enforceable patents. It's also very important and crucial to adopt the right strategies for a business to be successful. I believe the foundation is based on building the right strategies. I will also be touching upon the importance of freedom to operate, having opinions on clearance searches before launching a product on the market. I'll also be highlighting some of the most important challenges for conducting freedom to operate search and analysis. And lastly, this is my favorite part, I would be offering some tips and tricks on offering advice to the business on successfully launching products on the market with minimal risk of infringement. If you have any questions, please feel free to ask as we move along. Since my background is from the pharma industry, I believe there are three most important phases for successfully launching products on the market for a pharma company. The first phase, which is the planning phase, is also known as the ideation phase, where lead candidates are finalized. Innovation and access to technology is the key. Moving on to the next phase, which is the research phase. An extensive and exhaustive search on patent documents is carried out at this stage. This generates awareness on what the competitors are currently working on. The technical team is made aware of all the documents that form part of the state of the art. The third phase is the commercialization phase. After freedom to operate search has been conducted and there are no blocking patents that are identified, then the business is free to launch the product on the market with minimal risk of infringement. There is some amount of residual risk that always remains, but it is very crucial to have clearance opinion before launching products on the market. So these are the three phases to be considered for successfully launching products. IP and business. As I've already mentioned, having a clearance opinion from an attorney is crucial for launching products on the market. Post the ideation phase, once a lead candidate has been finalized, the whole entire process begins by searching for documents on all the various intelligent databases that are available. If the search identifies any blocking pattern, then the next step is to work on clearing those obstacles from the path to enable launch of products with minimal risk of infringement. There are various alternatives that are available to clear the barriers. For example, the company could consider looking for potential licensing partners, or maybe going for acquisition deals, or maybe even inventing around known patents. However, if the search does not reveal any blocking patents, that is, there are no relevant patent documents in the art, then there's always an option of generating IP, valuable IP for business. The question here is whether the technology meets the patentability criteria or not. There are two options available. If in case the technology or the invention meets the patentability criteria, then there is always an option of generating IP for business, that is protecting the technology by filing a patent application. Another option available for business is to opt for defensive publication. It's an inexpensive method of preventing competitors from filing a patent on a particular technology which the company might want to utilize in future. At the end, it all boils down to choosing the right path. It is always advisable to consider all the options that are available, whether it's licensing or whether it's acquisition or designing around, to consider all the options at an early stage of product development. We'll proceed on to the next slide. We all know that litigation is expensive, litigation is risky, and litigation is uncertain. And companies always want to avoid the complex procedure of getting involved in litigation, as it takes a massive hit on the reputation of a company. There is also a massive amount of investment that is involved in product development, commercialization, and development. Therefore, it is really, really critical to assess risks appropriately, to provide the right advice to business. Risk management is important because commercialization, as we all know, commercialization involves a lot of investment. Market forecasting, it's complicated. Advertising, commercialization, other commercialization tasks involves a lot of expense. This is the reason why freedom to operate should be conducted at each and every stage of product development. It's important to evaluate the risk in order to prevent being blocked from making, using, or selling the product. There are often times when a company is taken off market because an unpublished application which was not published at the time of search gets published. So there's always the risk of being taken off market, which has to be always evaluated and considered. Freedom to operate provides a roadmap that can help stay clear of risks. No search is ever complete, but still, it would help in providing a roadmap to stay clear of risks of infringement, which takes a massive hit on reputation of any company. A successful business is dependent on the right kind of strategies adopted by companies. That's why it's very important to adopt the right strategy at the right point of time. We have pending applications, expired patents, and in-force. What are the two options available for us to consider? It's either to opt for freedom to operate searches or landscape analysis. I believe conducting landscape analysis provides to the R&D team very, very valuable insights, so that the technical team becomes aware of what is known in the art, of know-how that exists, and to utilize those skills to generate valuable IP. The technical team could even propose new solutions, novel solutions to known existing problems, which could help in creating valuable assets for company, which could further be used for cross-licensing deals. Another aspect of freedom to operate is to identify safe markets. There may be jurisdictions where innovator companies might not have filed patent applications, so those are known as safe market. If company has the potential to manufacture and launch products in those markets, then it provides really, really valuable insights to targeting such markets and launching new products in those jurisdictions where there is no patent protection. In most of the emerging markets, innovator companies have just started filing applications where products that have been on the market in developed countries the patent application hasn't been filed in those jurisdictions. Another advantage of conducting a top quality freedom to operate search and analysis is to provide insights to the business team on acquiring companies or looking out for potential licensing partners to license patents so that companies can launch product without the fear of infringement. So it's all about adopting the right strategy at the right point of time. An FTO search helps in finding IP white spaces where there might not be any patenting activities involved, and this in turn helps in avoiding the landmines. The first step in an FTO process is to conduct a top quality freedom to operate search, to perform search on various intelligent databases that are available and to compile a list of relevant references. The second step is to involve a qualified patent attorney, whether it's an in-house patent counsel or an outside counsel. To engage an outside counsel is always a good idea to get either an oral opinion or a written opinion in order to avoid willful infringements in future. The next step of patent analysis involves comparing each and every element of a claim to products. So this is extremely crucial to identify the relevant patents and to minimize the risk of future litigation. Reviewing file wrapper of target patents, that is going through the prosecution history to get an understanding of the statements made by the patentee, is really, really important. It helps in accurate interpretation of the claim because a search quality is dependent on how the claims are interpreted. And what if really, really broad patent applications are granted, which could potentially block the product from being launched on the market? It is extremely important to review the validity of target patents. In order to have very strong non-infringement position, because management doesn't like surprises, they want to be aware of any potential risks that may exist with the launch of any product on the market. So we need to have very, very strong invalidity arguments in case business decides to go ahead with the launch of product after being aware and evaluating the risks accurately. So it's all about having a balanced approach. I'll be broadly covering the most important aspects of freedom to operate search. Freedom to operate search plays a key role in risk evaluation. It is very, very important to evaluate the risks appropriately in order to avoid future litigations, infringements, and also to avoid willful infringement. It helps in demonstrating the intent of companies. A very interesting aspect of freedom to operate could be to generate IP. The technical information that is disclosed in the patent applications could potentially be used by researchers to propose novel solutions to existing problems, which could help in generating valuable IP for business. And this in turn could be used for identifying or approaching for licenses or cross licenses, or maybe it might even play a crucial role in acquisition deals. It could help in generating valuable IP for business because there's so much technical information that's disclosed. I've already mentioned about licensing opportunities. It's always available to look for potential partners to launch products on the market. And then another important aspect of an attorney's role is to work in close collaboration with the technical team to invent around known patents. There are some patents which cannot be designed around, and these are polymorphic, these are API patents, but there are the polymorphic forms that could be designed around. So patent attorney's job is to work in close collaboration with technical team to help the technical team design around formulation patents, and process patents are relatively easier to be designed around, but there are some patents that cannot be designed around. There are various challenges, and I'll be covering the most important challenges associated with conducting freedom to operate search and opinions. Searching is impossible. More than 2.2 million new documents are published each year. No search is ever complete. There's always some amount of residual risk associated with conducting freedom to operate searches. And absolute guarantee is never attainable with any search, no matter what the quality of search. Then there are language barriers which may prevent efficient searching and accurate evaluation and interpretation of claims. Sometimes we may seek advice from translators to accurately interpret claims. And then there are various challenges associated with finding patent equivalents filed mostly in emerging markets. It's not always possible to guarantee that there are no patent applications that are pending or published or granted in emerging markets, in Russia, China, Middle East, where information is not readily available online. FTO analysis, like I've already mentioned before, FTO analysis can never guarantee that a company will not be sued. So there is always some amount of residual risks associated with conducting freedom to operate searches. We have the risk of unpublished applications, and also database limitations are there. It depends on the date on which the database was updated. And then patents and applications identified from the search always depends on the quality of the search, and the degree of relevance of each patent is subjected to interpretation of claims. So it depends on the quality and claim interpretation. Some attorneys may have a different interpretation, so it depends. That's why it's so crucial to refer to prosecution history to understand and accurately identify the claims and to understand the language. Over here, I'll be offering some tips and tricks to advise the business on successfully launching products on the market. It is important to understand risks in order to limit liability in future. At an early stage, that is the project kickoff stage, it is advisable to conduct landscape searches to understand the risks involved and to work in close collaboration with design team to design around known patents. Next stage is clearance stage. Prior to the design freeze stage, it is advisable to conduct clearance searches and analysis. It is also advisable to get opinion from an outside counsel at the design freeze stage itself. And just prior to product launch, we have to get a written opinion from an external counsel. And this will result in a successful clearance analysis. As I've already mentioned before, attorneys should work in close collaboration with technical team to make them understand and provide guidance to design around known patents, the relevant patents, so that the risk is minimized. In a nutshell, it is to be determined what is reasonable, and then we need to make informed decisions. It's very important to adopt the right strategy at the right point of time. To conclude, I would like to say that the ultimate goal of any pharma industry is to have a broad portfolio, have a very strong pipeline of products, and to successfully launch products on the market. The value addition is conducting world-class FTO searches and opinion in order to achieve that goal. FTO analysis are crucial to prevent future litigation, as litigation involves a lot of time and money. To ensure successful market launch of a product, it is important to have a top quality FTO and clearance opinion from attorneys. Investing enough time and money in an FTO analysis is very crucial, and it has to be done at the right stage of the development cycle. And this would save a lot of time and money for business and allow a barrier-free entry with minimal risk of infringement. To conclude, I would like to say that although a residual risk will always remain, but FTO analysis will provide the business a roadmap to steer clear of infringement risks and to prevent future litigation, as litigation is expensive and every company and business would like to avoid litigation at all costs. That's all I have. Do you have any questions? Okay, thank you very much for your time. I hope this information was useful.